We're talking to international law expert, Attorney Romel Bagares. Good afternoon, Attorney Bagares. Good to have you back.
Good afternoon.
Hi, Attorney.
Hi, sir. Good afternoon.
Kahapon sa ating mga nanonood.
Okay, so I guess first things first, which is next week na po yung confirmation of charges hearing for former President Duterte at the ICC. It's still unclear at this point whether he's going to be appearing in person or via webcam, via Zoom. What are you expecting in terms of outcome from this whole week of confirmation of charges
Actually,
hearings?
since you mentioned na rin yung he might appear on webcam, if I can squeeze in na rin. But sir, is it required sa confirmation of charges that the accused appear? Can he be made to appear before the chamber, or can he waive his appearance?
Yes. Well, in the rules of the ICC, you can actually waive your appearance.
You cannot.
In the confirmation of charges. Anyway, the lawyer is still there. Attorney Mr. Kaufman is still representing the former president. So what is required by the rules is that the waiver was properly executed, meaning it was not forced. You know, the form prescribed is complied with, and the chamber is satisfied that it was actually executed on his own volition. You know? So it's really up to the chamber, but generally in theory, the chamber can actually refuse or deny. But I think we have examples in the Ruto case in 2014 when such a waiver was granted by the ICC. Although I understand the prosecutor filed an opposition to the request for waiver of appearance.
So you're saying it's up to the chamber to decide. In other words, it's not an option for the accused to say na I don't want to appear.
Well, technically they've already rejected his motion to not appear personally. But now that what happens now? So now that the court has rejected it, they will physically drag him to the court, to the hearing?
No, I don't. As far as you know, there is no ruling yet by the chamber. What we have is an opposition from the prosecutor. Yes, but I don't really think that it's going to be a problem. Looking at the form filed by Duterte's lawyer, it can be reasonably inferred from the form that the president actually executed that out of his own volition.
Yes, sir.
Complied with the requirements of the ICC. What is really important is that he does not need to appear in the confirmation of charges proceeding. And there's a provision in the Rome Statute that allows waiver of appearance at this point.
Okay, so he cannot be forced to appear. He
cannot be
opt
forced
not
to appear at this stage.
It's not like
Pero
an arraignment.
in lieu of in-person appearance, pwedeng ganun lang na may background ka lang at he will still have to be there kahit by Zoom, ano?
No, but that's exactly the purpose of the waiver, that you don't in any way, whether video or online or physical, don't have to appear. We have a similar thing in Philippine courts, right? When you file a motion to be excused from the proceedings, you can totally be excused, meaning there's no alternative means of appearing in court required of you once you have that waiver granted by the court. So it's the same thing in the ICC. There's such a proceeding accepted by the rules of the ICC.
Yes, sir. So, sir, I'm trying to look for parallels here in the local context. So itong confirmation of charges is parang PI, preliminary investigation, in which case you are not required to be physically present if you choose to waive. You need to be present lamang if it's an arraignment. Kasi that's that's plea na eh. So if you're not there, you cannot be arraigned. Tama ho ba? Am I getting it right?
When it's trial, the presence in general, you are required to be present during trial. Here, this is confirmation of charges. You can waive your presence. So what we have now is a setting, and I don't think that's going to be delayed. But it's important to note that this is not trial proper, right?
Yes,
this is actually
Yes,
another stage of judicial screening to make sure that these charges are not politically motivated. So You have the preliminary examination, you have the preliminary investigation. This is the tail end of the preliminary investigation. But between the PE, the first stage, and then the issuance of the arrest warrant, there are different evidentiary thresholds that are observed by the court. So this one is like a little bit higher. It's now substantial grounds to
Substantial.
believe that the accused
Yeah.
committed the crime.
Significant
That's the
grounds.
threshold that the prosecutor has to hurdle for the case to move to trial. Before, at the time when there was a request for an arrest warrant, the threshold was a reasonable basis to proceed with the investigation. So it goes higher and higher as the proceedings move along.
Yeah, yeah.
So it's really a safeguard instituted by the rules of the ICC to protect the rights of someone faced with a case like this,
Yeah.
to make sure that that the charges are not really politically motivated, and that there in fact are pieces of evidence to support the charges.
Let me just take 1 second to correct myself there. You're absolutely right, attorney. It's the prosecutor that opposed the motion of Duterte to not appear in court. They said that there's no reasonable cause for him not to appear in person during the confirmation of charges hearing. I also just want to take a second to read out your full title and description. You are former counsel of the Philippine Coalition for the International Criminal Court and also professorial lecturer in international law at the Philippine Judicial Academy in 3 law schools. My earlier intro was very short kasi international law expert, so I think I owe it to you to read out your full title.
And former reporter.
Okay. Yun pa
Yes,
pala.
Ms. Pamintuan was my boss.
Ayun, there you go.
Yes.
For 8
Star.
years.
Summer report.
So what's it like talking to your
Mas
ex-boss?
bata yan sa ating lahat. It's quite young.
Kamusta naman
Pero
talking about your
attorney,
ex-boss?
the arrest warrant can be issued anytime, even during
Yes, this is
Anytime,
this is
kahit
different.
ngayon.
As soon as the pretrial chamber actually approves the
yes.
PI, the preliminary investigation, the prosecutor may request the issuance of an arrest warrant.
Yes.
But this is not done in Duterte's case, actually. It took the
Yes.
prosecutor took some time to gather evidence because there were preliminary or interim exchanges between the Philippine government and the prosecutor. So during that period, the prosecutor made sure that it had actually given the Philippine government sufficient time to respond the proceedings, and then that's why there was a lag. But according to the rules, the prosecutor can request the issuance of an arrest warrant as soon as the authorization to a PI is granted by the chamber.
Yes. Saka yung confirmation of charges, it can be amended later kasi parami ng mga complainant May impact ba yun sa actual nature of the charge?
It can, 3 ways. This can end 3 ways. The first one is the chamber denies the entirety of things, right? So counts there can say there's no evidence, throw it out, and say, or
Yes.
the court would say gather more evidence, or the court would say this will proceed on
Move forward.
a few counts because there's several counts here, right?
Yes.
Or the court will say, okay, all counts we find sufficient or substantial grounds to believe that a crime has been committed on all the counts, and then this will move to trial proper. It will be transferred to the trial division.
How significant?
In that sense, this is different because in a Philippine proceeding, it's the prosecutor that controls everything at the stage of PI. It's not yet a proceeding. You have judges, but here it is a combination really of the civil and common law traditions. So you have judges that take part in the preliminary investigation. It is called the pretrial chamber. So each step of the way, the prosecutor needs the permission of the pretrial chamber to move.
Okay.
How do you think Duterte's petition to not attend the confirmation of charges hearing, wherein he said he's old, tired, and frail, and anyway he doesn't believe in the jurisdiction of the court, how do you think that's going to affect his case, if at all?
Well, I think that's really legal strategy plus drama, because remember, there's a pending appeal before the appeals chamber on an earlier decision by the trial chamber. on the rejection of jurisdictional challenges under Article 19 of the Rome Statute. So that is now pending before the appeals chamber, and I think the lawyers for the president is thinking that we have to be consistent with our theory that there was no jurisdiction from the very beginning. So we have to make sure that the President Duterte actually files this manifestation in court. We don't recognize the jurisdiction at all. The president was kidnapped. So that's really the narrative that the lawyers for the president are trying to craft here, so that the appeal now pending before the appeals chamber will mirror what's happening at the pretrial chamber proceedings.
Sir, defense lawyers were earlier trying to have three lawyers of the victims taken out of the list. We're trying to divine the logic or the reason behind it. Kasi supposedly it's conflict of interest because they worked with some of the victims in the past. Kasi in the Philippine context, parang hindi naman problema yun kung gano'n. Pero I'm wondering bakit sa ICC, iba bang patakaran pagdating sa ganyan? What's the conflict of interest there?
Well, first a disclosure, because I could advise here. All three counsels used to work in the same law office.
Yes, sir.
For a long time. So I think viewers should be so minded to take note of that important point. But in the ICC, it's really rather strict. In the proceedings, for instance, you have a case here of a lawyer who was caught talking to a witness from the other side, and he was disciplined by the court. No?
Yes, sir, but it's the other side.
So there's really a strict divide there. But I don't really think that there should be any basis, no? Because right now it's actually victims' participation representation. It's a unique device in the ICC. We don't have that in Philippine courts, by the way. And that's drawn from the past experience of prosecuting international crimes like the former Yugoslavia, where it was thought by experts that there was a lack of victims' voice. So this is not yet trial, and the participants, in fact, none of them, according to the rules, will be allowed to speak orally. It's all paper pushing. It's all filing of papers and documents would be heard. The people, the victims there will not speak unless there's a very rare reason. I haven't come across any case of that sort, right?
Okay.
So this is really just representing the interests of the victims, because technically we're not yet at the trial stage where you have a separate set of counsels for the victims. So this is part of the victims' participation, just to make sure that their views are heard, their concerns are heard at this stage of the proceeding. But it will not be, like what you'll find in Philippine courts, where you put on the witness stand a victim, and the victim will testify, and the other side will cross-examine. That's not going to happen.
Yes, sir. Well, sir, since you already mentioned the other previous international tribunals like Yugoslavia, can I also ask another question? Medyo kambi lang ng konti. Your former colleague, si Harry Roque, we were discussing with him the other day the issue. Ang insistence kasi ni Harry was that the ICC has veered away from the I suppose traditional practice daw of other international tribunals like the one for the former Yugoslavia and the one for Rwanda, where almost always daw, and I am putting that in quotes, almost always, because Harry kept repeating that phrase, almost always binibigyan daw ng interim release ang accused dun sa Yugoslavia and Rwanda tribunals. We
fact-checked
it, and parang what we're coming out with is it's actually rare. But what do you know? Who is it really almost always or rare na nag-interim release?
The percentages were really low when we looked at it in the cases in Yugoslavia and Rwanda.
What I can say is that if there were any instances of interim release, whether ICC or the other tribunals, these concerned cases that are not of this serious nature, crimes against humanity, war crimes. Not the accused are, not faced with these sorts of serious offenses. So I think that's one thing we can see from the jurisprudence of the ICC, for instance.
Yes, sir.
I think that, and the reason for that, I guess, is because of the gravity of the offenses charged against a person. that's taken into account by the court with respect to request for interim release.
Yeah. Yun na nga yung sabi ko kay Attorney Roque, Attorney Bagares. I said, from what we know, crimes of humanity is amongst the most heinous of crimes, and therefore the bar for interim release is very, very high. And he said, mali daw ako. But in any case,
Personal lawyers,
Yeah.
you know, that's actually the funny thing here is that Attorney Roque also used to be my boss in the
Yes,
same
sir,
law
we know.
office to which the
Yeah.
counsels now appearing also belong, right? But I am no longer part of the law office, been not been part of the law office for some time. But I think that I recognize, you know, the positions taken by different lawyers. It's part of advocacy. But what I can say as an academic is that the interim release has not hardly been granted with respect to someone accused of
crimes against humanity.
the serious charges like what we have right now, crimes
Yeah.
against humanity.
Yun na nga eh.
Yes, sir. The numbers we came out with were mga 2% lang for Rwanda
4%,
of those indicted
20.
and 20 to 30% or 25% for those indicted by the Tribunal of Yugoslavia.
And that was a long time ago. So more recent cases, those who've been convicted of crimes against humanity have usually been sentenced to minimum 12 years.
So medyo malayo siya doon sa almost always.
And yeah.
But anyway.
Pero attorney, attorney,
had to ask.
all indications point to the trial proceeding, ano?
Yeah,
Ano yung reason? Lahat ng mga tao nagtatanong, kailan po mag-umpisa yung trial? Between the confirmation of charges saka yung arraignment, ano yung reasonable time kung matutuloy, ha?
I think I actually spoke to one of the victims participation council, and the estimate is that probably trial will start if charges are confirmed in June this year.
June?
June this year.
June,
That's
okay.
By June.
That's their own estimation. I mean,
but that
the
could-
IPC might have a different time frame, depending, of course, on what's going to happen.
Yeah.
If-
the confirmation of the charges.
if the chamber decides that the case will proceed, can the defense appeal it again and thereby hold up the timeline?
Yeah, yes, but generally the appeals do not really impede the conduct of trial. As you can see in the earlier order of the PTC on jurisdictional challenges, the PTC rejected the challenge to jurisdiction filed by former President Duterte's lawyers, and that's now pending in the ICC. That has not in any way impeded the proceedings, such as the continuation of the confirmation of charges.
Sir, the 60 days for the pretrial chamber to make a decision on the confirmation of charges, is that the maximum, or is that parang you cannot decide
That's a regular
earlier
timeline.
than 60 days?
Well, I haven't seen I've not checked the periods, but generally that's the period for a proceeding like this. And I think the ICC now is more carefully minded with respect to the periods in question. So they have come out in new rules to stress the importance of timeframes to both the prosecutors and the defense counsels.
Yeah.
And they're going to be very strict about that.
Okay, fair enough. We will leave that there. Thank you so much for explaining all of that to us, international law expert and former counsel to the Philippine Coalition for the International Criminal Court.
And former star reporter.
And former star reporter. And former center law lawyer, attorney Romel Bagares. Salamat,
Thanks, sir.
You're welcome.
Thank you, attorney.